And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today might be the day I earn that subscription. For today's story, we are talking about the lawsuit as a follow-up to the Uvalde school shooting at Robb Elementary in Uvalde, Texas. You'll remember this incident. A person went into a school and shot up a whole bunch of people. What is most notable about it is that there was something like 300 police officers who were there for the majority of the time doing F all. They were just kind of hanging in the halls and doing nothing. Despite the fact that some of the kids were calling 911 from cell phones and begging for help, the police, knowing this, just stayed there and did absolutely nothing for very long periods of time. And yeah, that's just super great. So we've got a lawsuit against the Uvalde Police Department and others. So we're going to cover for $25 billion or $24 billion. What's $1 billion between friends, I guess. Anyways, that's been filed in the Western District of Texas at Austin Federal Court. So we'll cover this. I go into it with unfortunate skepticism, because as we've discussed on this channel, the general rule is that there is no affirmative duty, and this applies even in a school environment. So the police have no particular duty to any particular individual. So we can't really get them for things they didn't do typically. But maybe we can try to get them for things they did do, or maybe we can try to find a way around this problem, but we'll see what's going on in any event. We'll try to look through it, try to see what our legal theory is, try to see if there's any hope for this lawsuit. Unfortunately, as we've discussed, the no affirmative duty thing from cases like Warren versus DC, or Castle Rock versus Gonzalez, or Winnebago versus DeShawnee. So we'll see if we can get around all that. All right, so here we are. We are in federal court. This was filed on the 29th. I think it only became public on the 2nd for some reason, but whatever. And we're going to cover this. This is from a whole bunch of people in a class/mass action. So a whole bunch of people are filing, and they've asked for a jury demand, and they are suing the Uvalde School District, the principal, the district police department, the chief of police, and some specifically named police officers. Which, if nothing else happens as a result of this, I hope that every single one of these police officers is named, because they should all be honored for their efforts that day. Great. All right. So we're suing a whole bunch of people and a whole bunch of John Does who we don't know the names of yet, but we have the names of some of the people of who were involved in the incident in question. All right, defendants. So let's go read this. Plaintiffs individually on behalf of all similarly situated students, student parents and or guardians, teachers, and support staff who were in attendance or had children in attendance, and who sustained emotional and psychological damages as a result of their conduct and omissions. So conduct maybe, omissions will be harder, but we'll see. By and through counsel, hereby file this class action. And they take a note here that the punitive class, the class action, does not include those people who had been shot or killed at the elementary school, presumably because they are not similarly situated, and also because they could sue on their own behalfs, or maybe they could be attached to this lawsuit at a later time. But at the moment, at least, this does not include anyone who was shot or killed. This only includes the other students who were there that day. And the other students there, the ones that were not shot and not killed, want $25 or $24 billion. We'll see about all that. The nature of the action. Regrettably, this court must preside over yet another reoccurring and deeply tragic occurrence where once again elementary-aged children and their dedicated teachers have been murdered and emotionally maimed by a deeply troubled young man wielding a semi-automatic machine gun. Lol. No. But okay. Who, in his delusion colored by glorification of violence perpetrated by both video games. Really? We're bringing video games in this. We're going full Jack Thompson on this thing. Okay. And targeted gun manufacturer advertisements mercilessly released his own childhood trauma and pain upon unsuspecting, beautiful, and buoyant young children and teachers at school. Dude, I don't like this way this is written. I'm sorry. I don't like the way this is written. This is so emotionally written. It's just like, can we get to the facts, please? The facts should be powerful enough by themselves, presumably. If we want $24 billion, presumably the facts are horror show enough. But do we really have to bring video games and all this stuff into it? The verbiage, man. The verbiage. This iteration of this now all too frequent tragedy took place on May the 24th, 2022 at the Robb Elementary School in Uvalde, Texas. Uvalde, Texas is a close-knit rural community located 80 miles from the United States and Mexican border. Robb Elementary School is a school administered by defendant Uvalde Consolidated Independent School District. In administrating the schools under its control, the district employed its own police department. Not only had the police department undertaken state-sponsored and mandated active shooter response training, that training worked out really, really well, I see, but the district had additionally promulgated its own required protocols and standards to employ in the event of active shooter of one of its campuses. Despite such preparedness, the police department, along with similarly trained law enforcement agents, including the city of Uvalde's police department, the Texas Department of Public Safety, San Antonio's SWAT unit, Uvalde Sheriff's Office, and the United States Department of Homeland Security, who for some reason were there. I guess they are within the 100-mile border of Texas, Mexico, so I guess that kind of makes sense, fundamentally strayed from conducting themselves in conformity with what they knew to be well-established protocols and standing for responding to an active shooter. Thus, on account of the abject failure of such highly trained law enforcement agencies, plaintiffs and their putative class will now be forced to endure indelible and forever lasting trauma that defendants immeasurably caused and amplified on account of their contemptible and flagrant affirmative conduct in failing to undertake prescribed courses of action. That's not affirmative conduct. That's kind of lack of conduct. Failing to undertake is not doing a thing. It's very specifically not doing a thing. Failing to undertake is not affirmative conduct. I'm having doubts on how we're getting past the affirmative duty problems. Plaintiffs and class members respectfully request this court does its part in providing the framework for redressing the harms that no amount of money can forgive or ever absolve. Well, okay. To some degree, you're basically shooting yourself a little bit in the foot on that one, because a court has to be able to make it redressable. So if what you're doing, if you're saying that this will not redress our injury, then that literally prevents you from having standing. So you want to be a little bit careful about that. Because to have standing, you have to have injury in fact. It has to be caused by the person. And the courts have to be able to do something about it. So if you're saying the courts can't redress us, you're defeating one of the elements of standing. Okay, it's brought under 1983 and under state law. Maybe there's some state-specific law, but probably not, because that was Winnebago versus DeShawnee. There was a state law in that case that said that the police shall ... with respect to a restraining order. And even that, the Supreme Court said, no, it's not enough. So they have the affirmative right to declare the rights of parties. Sure, declarative relief, yes, but unfortunately, the Supreme Court precedent's pretty strong. Rule 65 of the Federal Rules of Civil Procedure authorizes court to grant injunctive relief and attorneys. Venue's proper because this is the proper place. So they got venue. And then they go through all the parties individually, which I will skip. They're either children of Uvalde, teachers of Uvalde, or, in the case of defendants, various governmental officials, including police officers. So we can skip all that because we know the parties involved. But once again, it does not include anyone who was shot or killed that day. At least right now, it doesn't. Maybe those people have to be excluded. Maybe they're not. Maybe the idea from the attorneys is that they're not similarly situated. It can't be included in the class, which is probably true. All right, skip. All right, preliminary allegations. Given the exponential rise in mass shootings in the United States and their gut-wrenching encroachment into school settings, school districts and law enforcement have been forced to reckon with this national scourge while having their efforts thwarted by callous and unrelenting Second Amendment advocates and opportunistic, profit-driven gun manufacturers. The Second Amendment is part of the Constitution. So, we should probably do that because it's part of the Constitution. Again, we could get into a discussion about what the Second Amendment means and what it doesn't mean. I have videos on my channel discussing that at some length if you're into that kind of thing. But whatever the Second Amendment means, much like whatever the First Amendment means, or whatever the Fourth Amendment means, or whatever any other provision of the Constitution means, what it means might be open to some discussion. But what it means, we should probably do that thing because it's in the Constitution. But apparently the Second Amendment advocates are bad, even though they're fighting for literally a part of the Constitution that exists. So, okay. Such reckoning has resulted in the aggregation of standards of care and protocols that provide school districts and law enforcement with predetermined and vetted courses of action that enable them to undertake swift, automatic, and highly organized response whose utmost adherence can save lives within fractions of a second. Doubtful as to fractions of a second. Doubtful that any protocol is that good. But their overall thrust, I tend to agree with. I mean, we learned a lot from Columbine, and Columbine was 25 years ago. So, nevertheless, protocols and standards are only effective if and when their dictates and tenets are complied with. I mean, true. Despite the fact that such protocols and standards pertaining to mass shootings were well in place, the Uvalde School District, as well as local, state, and federal law enforcement, were woefully in breach of these well-established protocols, when in fact their implementation was gut-wrenchingly triggered. I mean, I agree that the police suck ass. You don't have to convince me of that proposition. I think every one of these police officers who was there that day should be named and their photograph displayed so that they can be honored accordingly to their actions. I think it is good to honor police officers for their actions. I think every one of them should have their photographs and names released so that they can be appropriately honored for their course of conduct that day. And that's what I think. I also think that, were I God, we would talk about them having some sort of individual responsibility, or maybe the pension fund having responsibility, because I'm sure that would get someone's attention. But alas, I have to be a good legal educator and inform you, despite my deep set feelings about the Uvalde police and their actions that day, which are quite manifest. Unfortunately, I have to give you the bad news, which is that due to case law such as Warren versus DC, Castle Rock versus Gonzalez, Winnebago versus DeShawnee, we have a problem because while the police have a duty to protect the public at large, that duty does not extend to any individual. It extends to people in custody. But again, unfortunately, the case law is quite clear that custody means arrest or the equivalence thereto, and is also quite clear it does not mean being in school. So despite my feelings personally, I have to actually obey the law, which is one of those things like, as a judge, if I were judge, it's one of those things where it's like, well, this is what I signed up for. I can't do what I want to do because the law, unfortunately, requires a different result. So I hate my life a little bit, probably, as I'm ruling for the police because it's not going great over here so far. But hey, maybe it gets better. Instead of swiftly implementing an organized and concerted response to an active school shooter who had breached the otherwise secured school building, at Rob, the conduct of 376 law enforcement, which apparently comprises of 149 United States Border Patrol. It's a lot of Border Patrol, but okay. 91 Texas Department of Public Safety, 25 Uvalde Police Department, 16 San Antonio Police Department SWAT, 16 Uvalde County Sheriff's Office, 14 United States Department of Homeland Security, 13 United States Marshals Drug Enforcement Agency, 7 Frio County Sheriff's Office, 5 Kinney County Sheriff's Office, 5 Uvalde Consolidated Independent School District, 4 Dilley Police Department, 4 Zala County Sheriff's Office, 3 Medina County Sheriff's Office, 3 Sabino Police Department, 2 City of Uvalde Fire Marshals, 2 Pearsall Police Department, 2 Texas Park and Wildlife, 2 Uvalde County Constables, 2 Valverde County Sheriff Office, 1 Frio County Constable, and 1 Southwest Texas Junior College, and 1 Uvalde County Constable were the people that were apparently there on that day. 376 people who deserve to be named, have their photograph released, so they can be appropriately honored for their efforts. So the 376 people who are on hand for the exhaustively torturous 76 minutes of law enforcement indecision, dysfunction, and harm fell exceedingly short of their duty. Yeah. I agree. I agree. Your only hope here is some sort of very specific state law. And it has to be even more specific than Deshawnee. It has to be even more specific than you shall enforce restraining orders. It has to be more specific than you shall save the children. Good luck. As with the largest contingent of law enforcement on the scene at Robb Elementary School, the Texas Department of Public Safety, the entirety of the Texas law enforcement departments, subscribed, trained, and were therefore bound by protocols provided by Active Law Enforcement Rapid Response Training, ALERT, a program created in response to Columbine in 1999. Was 1999 so long ago? Ugh. And considered the national standard, provides Texas law enforcement with standardized training. Yeah, after Columbine, we kind of learned that you go in with what you have and you stop the threat. That's the basic protocol in response to a school shooting. But not so much. Primarily, the alert protocol requires responders must have tools and training to immediately and without delay make entry neutralize. That's basically the basic principle. Right. In response to an active shooter, you go in immediately and try to stop the threat. That's the basic gist. Thus, when a suspect fires a weapon at school, he remains an active shooter until he's neutralized and is not to be treated as a barricaded subject. Alert training lucidly distinguishes Alert training lucidly distinguishes between a hostage barricade and active shooter scenarios. Relatedly, under the alert protocol, law enforcement's first priority is to immediately stem the killing of innocent civilians, and every law enforcement officer is expected to willingly risk his or her life without hesitation. Hence, law enforcement officers are expected to distract, isolate, and neutralize the threat, even in tactically complex scenarios. Again, this is my basic understanding of the protocol. I've never been through the training, of course, but, there's enough information in the zeitgeist that, yes, this conforms what I know. As such, alert mandates that from the moment forward, every law enforcement officer is expected to be willing to risk his or her life without hesitation. A lot of officers failed that test. Such overriding mandate exists to stem the ensuing damage caused or by swiftly moving to neutralize the shooter. Time is of the essence, as the longer the shooter's active, the more carnage accrues. I mean, duh. In order to establish a coordinated effort to effectuate the overriding mandate of swift neutralization, excuse me, the alert protocol requires the prompt establishment of an incident command structure. Incident command will be established by the first law enforcement responder who arrives on scene and is charged with immediately providing dispatch with a brief location, condition, action, needs report. Thereafter, the responder immediately assumes immediate command. Further, as soon as law enforcement responder notices that there appears to be sufficient officers hunting for the shooter, that responder should find a secure location, take out their active shooter response card, assume initial incident command, and begin completing tasks listed on the card. Thereafter, the incident commander disseminates vital information, location, condition, actions, and needs to all subsequently arriving law enforcement and emergency services who arrive. The alert protocol stresses that the earlier an incident command structure is established, the more prompt and successful response can be achieved. Thereafter, once an active shooting scenario grows larger, both temporally and in complexity, the first responder who initially assumed incident command position must pass on the command position to an officer of higher rank or level and or department with more widespread jurisdiction. Thereafter, incident command should move off premises where an overall commander will take charge and assume control of the unfunded and control of the emergency. This all sounds pretty reasonable given what we know, right? The first person who's on scene, take charge. Stop the shooter. And, if there is time at some point, then, transfer it to an outside command, but, stop the shooter. And this all sounds pretty reasonable in response to what we know. With respect to accessing closed or locked entryways or exits, alert protocols clear and mandates that responders should be creative and make use of improvised tools to get inside the building however they can. Wow. Didn't think about that one. I should just use whatever's around and handy to try to gain access to the building. Couldn't have thought about that myself. Yeah. With respect to using keys to gain entry, alert counsels that the quickest, most discreet, and safest entry method is to locate a key as long as it can be located immediately. But if it cannot be located quickly, which I'll note is different than immediately, law enforcement responders should use another technique to enter the area without delay. Alert suggests sledgehammers and pry tools. It's disappointing when the active protocol kind of makes just common sense, because it's like, why didn't you follow it? Right now, that it's something you need to be trained on, because in the moment everyone panics. Right? That's so it's something you need to be trained on. Okay. Although all defendant law enforcement agencies subscribe to alert protocols and standards, the defendant independent school district additionally adopted its own standards and protocols set out in a register entitled Annex 1 Active Shooter. The Annex 1 was adopted upon direction from the state of Texas, mandating every school officer in Texas must be trained on how to respond to an active shooter. The protocol annex outlined the operational concepts, responsibilities, and procedures required in order to coordinate the response to an active shooter by the CISDs, administrators, teachers, district police officers, and local law enforcement. As with the alert protocols, which I note they misspell, but it happens to everyone, the annex program stressed the importance of neutralizing the shooter as a number one priority. The priority of life scale dictates that innocent civilians are prioritized over law enforcement and other responders. Thus, the index mandated that the police, administrators, and teachers have a daily responsibility to mitigate and prevent an active shooting scenario, including conducting inspections of classroom to make sure doors and windows can be secured, Doors to all classrooms remain locked during instruction, and that each staff member will know the procedures to follow in order to have any door or window repaired that will not lock. In addition, the protocol circumscribes policies in order to diminish the risk of an active shooter occurrence. For example, the annex required that each campus convene a team to identify, evaluate, and address potential threats of school security, including the monitoring of all social media that suggests connections to Uvalde in order to identify potential threats. Perimeter fencing is required to restrict access to the school, as is staff emergency training, procurement of radios to support communication. Police are private businesses and for profit. Please read Article 4, Section 1 of the Constitution. Okay, I'll bite. Let's take a look. Article 4, Section 1. Why is it not scrolling far enough? Okay, Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and effect thereof. I'm not really seeing how Article 4, Section 1 speaks to the police being for profit, but thank you for your contribution to the chat. Let us move on. I'm not seeing the relevance of Article 4, Section 1 on the issue, but thank you. Okay. The annex designates the district police department chief as officers responsible for coordinating the efforts of all law enforcement and first responders who arrive on the scene, and the district administration office should be utilized as an incident command post and should contain the school's emergency system that include communications, staff and student locations, and detailed floor plans that are readily available for use in coordinating the response. The annex stressed that all law enforcement, outside law enforcement, and first responders should follow the direction of the district police chief and accept their assigned roles. Okay, well, we've learned a lot about the protocol, which kind of sounds exactly like we would think it sounds, but we still have the problem of how are we getting to a duty that extends to any of these people individually. And if none of them have standing, they don't all have standing collectively. That's not how that works. All right, so let's look at a statement of facts. Read Supreme Court 22-380. Why don't you just give me the name of the Supreme Court case? Like a normal person. What case? You know, made me look up what 22-380 is. Why don't you just tell me the name of the case? Prior to May the 24th of 2022, compliance with safety protocols and physical conditions at Robb Elementary School were more than deficient. For example, the school's 5-foot-tall exterior fence was negligible for impeding a would-be intruder. Both defendant Robb Elementary principal and the chief of police were well aware of this Achilles heel in the infrastructure, but failed to make steps to affirmatively reiterate its school shootings in protecting would-be intruders. I will take hey, look at that. We have some gift memberships from someone in the chat. It's All BS has gifted 50 uncivilian memberships to viewers. Well, thank you, It's All BS, for your 50 gift memberships. That's incredibly generous and very, very appreciated. If you'd like to also get a membership of your own, it is a mere 99 cents. How do you get one of these memberships? Well, my friends, it could not be easier. You hit the join button on your screen. And if you don't have a join button, although you probably should because I think it has rolled out to iOS, but if you don't have a join button for some reason, not to worry, my friends. It is the first link in the video description. And also, it is given to you from the bot from time to time for a mere 99 cents a month. It is literally the least YouTube will let me charge you. You can be an uncivilian and help to support this channel and its growth. I need your help. I really do. And the more of you who help join, the better things will be. Because, for example, at the moment, I'm doing my own editing because editing is really expensive, given what people charge. It's like I can't really afford this, and I can't really afford to travel to do things like go to trials in person, because that's expensive. It might be nice, for example, for um, the trial with the cult murderers to be able to go in person if they're not going to tape that, but of course that requires expense. So, but you can help the channel, and you help by a mere 99 cents. So if you click that link, if you click that join button, or you click the link in the video description, or the link that the bot tells you about from time to time, you will be able to do all those things. And thank you very, very much. Once again, that's all BS for those 50 gift memberships. Let us return to the channel, or to the story. Don't. He's not spamming my chat anymore. Thank you. While school safety policies mandate that both the school's external and internal doors were to be consistently locked, there existed a culture of noncompliance by school personnel who perpetually and deliberately circumvented the requiring of locking of doors by consistently propping them open. Unless this was a cause in fact on the day, it doesn't really matter, but okay. The school administrators, including the principal and the chief, as well as the board, were all well aware of such policy breaches, but rather than address them, they chose instead to permit their continuation. Despite being apprised that the doors to many of its classrooms, including the ill-fated 111 and 112, were unable to properly lock, they failed to ensure that such locks were repaired. Okay, well, maybe, but if they weren't properly locked, the police could have opened them, and maybe they didn't even try. The principal, the police chief, and the school board were additionally apprised that Robb Elementary's emergency warning system was significantly compromised on account of perpetually poor internet coverage and mobile phone service. Such paltry service also negatively impacted police radios, whose connectivities were constantly challenged. Why would that impact the police radios? But okay. On account of Uvalde's proximity to the Mexican border, it's within the 100-mile zone that the Border Patrol uses for their purposes. There were frequent instances of Mexican human traffickers crossing the U.S. border while being pursued by U.S. Border Patrols. The traffickers would purposely crash their vehicles in order to permit their smuggling patrons to scatter. In response, the administrators and police at Robb Elementary would sound an alarm via its Raptor system and either designate a secured area or lockdown alert. The frequency with which these bailout, secure, or lockdown alerts took place, 50 lockdown alarms between February and May of 2022, led the school staff to disregard the warnings and treat the alarms as little fact or low concern. I mean, that is a problem, right? It's the boy who cried wolf problem. So if you set off an alarm too often, the alarm becomes ignored. Rather than creating different alarm signals for different kinds of emergencies, the administration relied upon only one signal whose frequent use, on account of 50 bailout lockdowns in 3 months, significantly diminished the urgency of response. I mean, that is part of the human condition, right? It's the boy who cried wolf. It's like every time this alarm, we rush and rush and rush, and then we learn that the alarm isn't really that important. When coupled with poor internet and cell phone reception, the school administrators and police departments were well aware the school's emergency response system for campus lockdowns was patently inadequate. All right, let's learn a little bit more about the school shooter. The 18-year-old resident school shooter significantly fit the profile of other school shooters. Well, his home life and upbringing were riddled with trauma that led him down a path of alienation and withdrawal, which was further met by bullying and ridicule. It's not a coincidence that the school shooter intentionally targeted fourth grade students, as he himself was subject to protracted bullying in his fourth grade year. I was also bullied in my fourth grade year, and also second grade, but didn't turn to violence. Bullying is not good. Thereafter, the school shooter withdrew from attending classes at age 17. He had only completed ninth grade. After withdrawing from school, the school shooter spiraled, and by the way, I'm making a deliberate choice in case you're curious to not say his name. I know it's on screen, but I'm not going to say it out loud. He doesn't deserve it. After withdrawing from the school, the shooter spiraled down a dark path with his friends, taunting him as a school shooter. Alienated, he found himself indulging in the first-person shooting video games. Oh my God, really? Are we really doing Jack Thompson now? Dude, no. No, why? Why are we doing this? Why are we bringing video games into this stuff? Dude, it's so weak. It's so weak. Really? You already have problems. Okay. But let's make those problems worse by bringing the video games into this. Alienated, he found himself indulging in first-person shooting video games, including Call of Duty and Grand Theft Auto. He found the attention he was seeking on social media by depicting himself as cold-hearted, violent, and aggressive character who displayed dead animals and play acted as a rageful gun shooter wearing body armor. Dude, no. Relatedly, he hinted on social media they intended to engage in school shooting and they became a welcomed attention notoriety. I'm really pleased, by the way, that all the members who are gaining this wonderful benefit of becoming members now we're getting the display on screen through this streaming app. I switched to Melon so I could get the alerts on screen. Also, it was a bit cheaper than StreamYard, and also I don't like StreamYard. So I thought I'd support a rival. But it's great. When you get the 50 gift memberships, everyone gets their acknowledgement on screen. It's awesome. Hopefully induces others to press that join button by saying, oh, look at those people. They got their name on screen. I want my name on screen too. Hit that join button, baby. Should be on your iOS device, or if not, it's literally the first link in the description, and also the bot tells you about it from time to time. In terms of would it be possible to get a gift membership, you have to enable gift memberships, and otherwise they're handed out randomly. So gift memberships are handed out randomly. So you have to enable it, but when the thing pops on screen, it should tell you to enable gift memberships, and otherwise it's handed out randomly. But it is only 99 cents a month. It's literally the least YouTube will let me charge you. For less than the price of a fifth of a cup of coffee at your Starbucks. For less than one fifth of one cup of coffee. For less than one fifth the cost of a gallon of gas for an entire month. Although 17 in 2021, the shooter attempted to effectuate straw gun purchases and began to amass gun accessories, including body carrier armor. Simultaneously with his purchases, he began to increasingly vocalize his obsession with school shootings. Upon his 18th birthday, he immediately purchased Daniel Defense DDM4 V7. That's an expensive firearm. Daniel Defense. But, okay. that he had shipped to a gun store in Uvalde. One day later, he purchased another rifle, a Smith & Wesson M&P 15. I'm not sure why he needed two of them, as well as 1,740 rounds of ammunition. That's a lot of ammunition at one time, but not unheard of, which he again picked up at a store. A background check was conducted, and despite him making multiple purchases, which were otherwise reported, he passed background check because buying multiple guns is not illegal. So, of course, he passed the background check because the Second Amendment, the First Amendment doesn't limit the number of books you can buy or how frequently you can buy books. So, whatever the Second Amendment means, it probably does not mean you're limited in the number you can buy per time. So, I mean, and also, incidentally, of course, as you would expect, they've also, in an unrelated lawsuit, sued the gun manufacturers. I probably won't be covering that one as much. But if there's a lot of interest in it, then maybe I'll cover that one too. But I don't think the gun manufacturers should be responsible. I don't think they should have been responsible in Connecticut either. I'm sure they're just going to copy paste the model there, but I don't think there was a valid cause of action. But I'm not sure that I'm going to follow that. On May the 24th of 2022, Robb Elementary was posed to celebrate the end of the 2022 school year with an award ceremony for its students and parents. Believing that this would also be the day his classmates would reconvene at Robb Elementary as a traditional parting gesture before graduation, he planned to carry out his attack to that day. On the fateful morning after a heated exchange with his grandmother over a mobile phone plan, he shot his grandmother and set off in a truck to the elementary school. En route to Robb Elementary at 11:28, he apparently did not know how to drive, lost control of the truck, which landed in a canal ditch. As the crash occurred in the vicinity of a funeral home, two employees walked over to be of assistance. Ascending from the crash, he began shooting at the employees, who fled for their lives back into the funeral home. Gathering his arsenals, he proceeded to Robb Elementary, which was adjacent to where he crashed the truck. He easily traversed the school's 5-foot fence, which turned out to be a negligible deterrent. He was spotted by a coach who was outside with third graders. He proceeded to shoot in the direction of the coach, who took cover and immediately reported active shooter through the school radio at 11:30. Expecting to immediately hear an overhead announcement the campus was being placed on lockdown, the coach shepherded her students from the playground into lockdown position. The lockdown announcement that the coach expected to circulate failed to occur. Another bunch of gift memberships. Thank you very, very much for the gift members. It's all gift. BS has gifted yet another 50 gift memberships to the people. Thank you very much. It's all BS for yet another 50 gift memberships. That is incredibly generous of you. Thank you very much. And congratulations to all the new uncivilians. I'm going to give you the plug again. If you would like to be an uncivilian, all you have to do, my friends, is hit that beautiful join button. It should be available on your mobile device of choice. But if for some reason it's not available on your mobile device of choice, not a problem. The first link in the video description is literally also a way to join. And also the bot gives you it from time to time. How much is it? It is a mere 99 cents a month. 99 cents a month to help support Uncivil Law and support this channel and its growth, which allows us to, for example, get equipment and lighting, and also would allow us in the future to perhaps have a room set aside for a studio. So I could afford a bigger apartment that would allow me to set a room aside for a studio and maybe have a better setup that way. Or it would allow me to travel to go see trials in person, such as the cult murder trial that is happening in Idaho, because it looks like it won't be filmed, but perhaps I could attend in person and cover it that way. Or other things that would enable me to provide more things for the channel. So all the help you give helps to support me. Plus, it allows me to eat, and that's also a bonus for me personally. So I appreciate it. So if you could help hit that join button, or help hit the join link in the video description, or the link the bot tells you about from time to time, and help support the channel for a mere 99 cents, it'll be supported. You get cool little scales of justice by your name. And also you get access to emojis. And also you get that feeling of warmth in your heart, knowing that you're helping to support an uncivil law. And that's all worth 99 cents. So I appreciate every one of you who is a member and will join by hitting that join button, and will also renew your memberships as well. Let's go ahead and get started with this. Okay, a teacher or a teacher class representative, I'm not sure if there's a difference, also heard the rattle of the gunshots from her special education classroom. After hearing the shots, the full-time special education teacher with students ranging from 2nd to 4th grade proceeded to the window and saw students and teachers scattering in all directions. The teacher promptly locked the classroom doors and shuttled her emotionally and physically disabled students into a closet within the classroom. After everyone was accounted for, there were approximately 13 students and teachers barricaded within the closet. Some of her special needs students understood what was happening and expressed fear. The teacher texted her 9-year-old child's teacher. So apparently she's a teacher's assistant, or no, to text her child teacher. So in the same school, I guess, to apprise her of the shooting and determine if the child was safe and under supervision. The teacher received a text back from the child teacher informing them that she's not with the class as they were in the cafeteria having lunch. As a special needs teacher, the teacher was equipped with school radio and heard the announcement of the presence of the shooter, but did not hear a campus-wide announcement and/or warning on the Raptor system. Such communication failure unfolded on account of the fact that the school's Raptor system failed to transmit because of well-acknowledged and persistently bad Wi-Fi signal on campus. Although impeded from broadcasting active shooter alert through the Wi-Fi, the principal did not attempt to communicate lockdown over the principal's intercom. She did, however, call the chief of police, who commanded her to shut it down, Mandy, shut it down. She thereafter instructed the school's head custodian to ensure all the school doors were locked. Can you imagine being that the custodian? It's like going around. Can you go around into the halls and make sure the doors are locked while there's an active school shooter? No, I can't. That is not in my job description. And if it is, I quit. Thus, all the lockdown was communicated amongst the school faculty by word of mouth. Many of the teachers who exited the building with their school students either heard the coach screaming or saw students running and in turn directed their students to run for cover. One such teacher ushered her students into room 109, where on account of yet another faulty door lock was required to forcefully slam the school door in order to engage the lock. She and her students then assumed lockdown positions away from windows and doors. Okay. Reading on. Thank you, Kiwi, New York Upstate, for the super chat. It makes no sense to sue your own government since you and every one of your neighbors has to pay a king's ransom in addition to taxes for paying for it. I mean, there's some truth to that. If it came out of the police department's budget or came out of their pension fund, even part of it, I think that would help more. But, you know. Meanwhile, the Uvalde Police Department dispatched the initial 911 report from the funeral home. The commander of the police department SWAT team and the Uvalde Police acting chief set off to Robb Elementary. Upon arrival, the officers met a different officer who were also on the scene. A sergeant saw the shooter shooting his AR-15. There were other Uvalde police officers present, as well as Department of Public Safety sergeant. At 11:33 a.m., so this is now like 4 minutes into the incident, we have apparently police on scene who are seeing the school shooter shooting, apparently. So that's pretty amazing for a response time, unfortunately. 4 minutes is a long time when you're being shot at, but unfortunately, pretty good for response time. It's like half normal response time, but they're on scene. The officers asked the supervisor for permission to shoot. And waiting for a response was too late as they already moved out from the site as the officer turned to shoot at Ramos. Well, why not chase him down? And why do you need permission to shoot if he's in the process of shooting? You know, that's okay. Although otherwise required under the alert protocol to immediately encounter and attempt to neutralize, neither of these officers undertook such action, nor did they set up an initial incident command in order to begin the coordination. Thus, the first responders failed and refused to undertake the required protocol to immediately distract, isolate, and neutralize. Yeah, they sound like horrible, horrible people. They sound like horrible, horrible people. So, this apparently is Sergeant Eduardo Canals, Acting Chief Marano Pargas, UPD Officer Javier Martinez, and Luis Landry are some of the officers who deserve to be named and honored for their events of the day. Okay, so now we have the arrival of the police chief. Soon thereafter, the Uvalde School District police chief arrived at the scene, having left his office at Uvalde High School. Despite knowing that he was responding to an active shooter, he failed to bring along his body armor or rifle. That seems like one hell of an oversight. Even more curiously, the chief of police, Arrendardo, upon alighting from his squad car, disregarded his police radio. Such a decision precluded his ability to perform his role of incident commander, who is required to set up communication command. Thus, at the outset, the chief disregarded his prescribed duties under the protocols. Meanwhile, the school shooter walked along the west side of the west building and then entered the unlocked door. So apparently at this time, when they first saw him, he was outside the building, if I'm understanding the timeline correct. Not that it really matters either way, but you know. Although here the west door, those exterior doors on both the east side and south side were also unlocked, such they had unfettered access to the building's interior. Once inside the building, he walked down the hallway and stopped in front of rooms 111 and 112. At approximately 11:30 a.m., he fired his AR-15 rifle towards room 111 and 112. It doesn't say which AR-15 rifle in this part of the thing. I'm not sure particularly why, but okay. Thereafter, he entered the door to room 111, which, as was the case on prior occasion, and which the school administrator had been properly apprised, was extremely difficult to lock, and as such was unfortunately unlocked and unsecured. Once inside room 111, he fired over 100 rounds, both inside the room and adjoining room 112. After 2.5 minutes, many students and 2 teachers were murdered. Many died instantly, while others died slowly. The school shooter apparently had no prior experience with firearms, and likely his shooting was the first time he fired a weapon. Terrified teachers and students throughout the West Building heard the extensive burst of gunfire, as did several law enforcement responders as they entered the building through the unlocked doors. Yeah, so we've already begun this a little bit. But I guess now we're going to be really entering the horror show portion of the stream. We've already talked about a little bit of it, you know, in the sort of leading up to it, and now we have him inside the building shooting people, and we're still within like the first couple minutes of this thing because the police were on scene. So we're still within like say the first 10 minutes of this, and now this is going to go on for 76 minutes. This is going to go on for another hour. So I suppose content warning, mostly due to the incompetence of the police. When you find the incompetence of the police more infuriating than the school shooter himself, which I do, you know something's gone horribly, horribly, catastrophically wrong. All right, let's continue on with the story. Law enforcement enters the school. I take note here in the footnote, by the way, AR-15 military grade capacity. In hearing the gunshots, the Uvalde Police Department Sergeant Canales turned to Defendant Department of Public Safety Sergeant Maldonado, who arrived on scenes moment before at 11:34, so we're within the first 6 minutes of the shooting, apparently, stating that we got to get in there, to which the sergeant responded, the DPS is sending people. Canales responded, he keeps shooting, we got to get in there. Go do it, man. Go do it. In less than 3 minutes after the school shooting began, the defendants approached rooms 111 and 112. So we're within 3 minutes of the school shooting, approaching the doors of the classroom. The officers, outfitted with body armor, 2 rifles, and 3 pistols, so it seems like we're equipped for the situation, took positions near the classroom. They heard shots being fired in the classroom, as well as shots erupting through the wall. Several of those bullets had careened through the walls and entered room 109, which was immediately adjacent. So we got body armor. We got rifles. We got pistols. We are standing outside the door. Within the first 3 minutes of the school shooting. Class student representative. Oh, I understand what it meant, finally. I understand what it means. I apologize. So when it said teacher class representative, I was confused. Because I'm like, what does it mean by class representative? That they're not a teacher? They meant class, not in the sense of school class. Like, that's what I thought. Like, it said teacher class. I'm thinking, oh, they're class of students, right? Because they mean the class in the sense of the lawsuit's class. So they're a representative in the class action. So, yeah. Ricardo Ospinilla has gifted 5 gift memberships. Thank you very much, Ricardo, for those 5 gift memberships. And thank you, everyone who is helping me become a non-civilian. Okay, so I understand what they meant. They didn't mean the teacher class representative in the sense of they're representative of the classroom. They meant a representative in the class action. Class student representative plaintiff JP was in room 109 when one of those bullets struck his beloved 4th grade teacher, Elsa Avila, in the abdomen. Her students, including JP, were horrified, but encouraged the teacher to hold on. Another bullet struck JP's friend and sheared off a section of her nose. As JP and his classmates were tortuously forced to endure the horror alone in their minds and bodies while listening to crying, wailing and grimacing of students in their own room as well as walls in the corners of room 111. Having experienced bullet piercing through the walls and knowing that more could arrive at any second, each subsequent minute of lockdown was an eternal hell for JP and his classmates. Okay. After 2.5 minutes shooting spree with sporadic gunshots thereafter, the chief, at approximately 11:36, along with the Uvalde police sergeant, Officer Page and Gonzalez, entered the south side of the building. Again, the chief, in disregarding the first principle of rapidly moving to neutralize the shooter, determined it was best to leave his radios behind, despite the fact that under the active shooter protocol, the chief was required to assume the position of incident commander to ensure a coordinated response. Nevertheless, upon information belief, no such incident command had been established prior to the arrival and or entry into the south side beginning. Although defendants Martinez and Canales had prepared to breach the doors, the officers were refrained from doing so after shots were fired in their direction. Soon thereafter, approximately 8 or 10 law enforcement, including Uvalde Police Department Acting Chief Pargaras, so this is the police department chief of the town, to be distinguished from the police department chief of the school district. So we have 2 police chiefs on hand. Gathered in or around the vicinity of rooms 111 and 112. Acting chief imparted the command to the police officers to stand down and not confront the school shooter. The sergeant informed others that the suspect was contained and barricaded, which the officers understood to mean they were confronting a non-active school shooter. Such was blatant misrepresentation, and moments before, he'd been actively firing his weapon. The defendant officers knew or had reason to know they were confronting an active school situation and not a barricade subject situation. Yeah, I mean, finding moral fault for these people is not hard. They had the training. They had the knowledge. They were there. They had the body armor. They had rifles. And they, probably out of mere sense of like preserving the innocent, probably should know in addition to the training, and they're not doing anything. Their moral culpability, their knowledge and mental state is there. So we've got mental state, we've got mens rea, we've got mental state, we've got mens rea, we've got knowledge, but where's our actus reus? That's the problem. Where's the act? Yeah. The sergeant knew this to be a case, but nevertheless erroneously described it as a non-active shooter. While inside the building, the officers attempted to communicate on their radios, but were unsuccessful on account of limited reception. Without the existence of an incident command nor incident commander, no one has set up an incident command. This absent included the acting chief of the town, who, despite perceiving a vacuum in overall incident command, refrained from assuming the role. In or about 11:41 a.m., the officers from the PDS arrived, including a fire marshal, a constable, and another constable who were instructors at the Regional Police Academy. Additionally, some other officer who was also a board member of the school district arrived and entered the building. So at this point, we are something like 10 minutes into the shooting. After the school shooter fired upon the officers positioned outside of room 111 and 112, the school district police chief gave the order to those of his command to stand down and not engage. Thereafter, the school district chief considered whether there were any students in room 110. Finding the door unlocked, the chief discovered an empty classroom and somehow jumped to the conclusion that not by seeing any injured students or teachers that the active shooter scenario had changed to that of a barricade subject scenario. That he was isolated and alone in the classroom, and such the strategy to rescue children in the adjacent classroom and wait him out. This theory unfortunately proved to be false throughout the course of 73 minutes, particularly when a series of 911 calls were received from terrified students who were huddled in agony in rooms 111 and 112, who confirmed the active shooting scenario was occurring. Meanwhile, Robb Elementary disingenuously announces on Facebook the school is under lockdown status due to gunshots in the area, but nevertheless, students and staff are safe in the building, and the building is in lockdown status. At the same time, the police department posts on Facebook, there exists a large police presence at the elementary. We're asking the public to avoid the area. Okay, well, I'm glad that's all going really, really super well. Everything is going just swimmingly great over here in every possible way. Yeah. I was just double checking that the streaming to Facebook is working, so I got streaming to Facebook as well, so that's nice. Let's see, where was I? The chief of the school district police, chief of the school's police, used his cell phone to call the town's police department dispatch and inquire whether a teacher was in the room with room 111. Thereafter, the chief admitted that he believed there were students and teachers inside the room with the school shooter, and that there was a strong likelihood of casualties. The chief of the school district's police repeated the same understanding, such that he repudiated his hunch that he was a barricaded suspect. Does anyone watch streams on Facebook at the moment? No. There are like 8 engagements. So no, but hey, why not? It's free. If Rumble ever gets single key streaming, I will also start simulcasting on Rumble. That's what I need. I need single key streaming badly. Does anyone go on Facebook anymore? Probably not, but you know, it's available, so we take what we can get. No one uses Facebook anymore. Go with the times. I'm well aware, but since it's available, why not? You know, for any benefit it might have. I mean, it doesn't cost me anything more. It doesn't cost me anything more. So at best, it does nothing, or at worst, it does nothing. And at best, maybe it gets me some additional traffic. So you know, whatever. Wow, thank you very much for liking the stream. I think that's a Facebook thing. So hey, someone on Facebook liked the stream. So hey, Darren Glover liked it. So there you go. There's one. The police department sergeant exited the building to make a call for dispatch rather than the non-existent incident command center, whose required existence went thoroughly ignored, requesting ballistic shields. Flashbang grenades and helicopter support. Ricardo Ospinilla gives another $5. Sad the good guy with the gun isn't the police. Word. Sergeant Coronado admitted that he was unsure as to whether the door to either room 111 or 112 was unlocked, and reaffirmed that the shooter was contained and barricaded with room 111. Sergeant Coronado remained outside the building for approximately 30 minutes while teachers and students and teachers were being evacuated. Push out windows. See, hey, there you got another one. While not located on the west side of the building, the teacher's class representative and her special needs and physically emotionally disabled students were escorted out of the classroom closet. All you people have said Facebook is pointless. I got 3 people liking the stream, man. Lol. Jim says, I'm commenting here so I don't feel like I'm wasting my time. I don't feel like I'm wasting my time. I got 440 people watching the stream, man. That's not bad at all. I'll take it. I'll take it all day long. The Facebook people are now representing. Hey, Fuel Me Once says, there you go. Fuel Me Once says, if it weren't for Facebook, I wouldn't have known you were streaming live this morning. We got one, baby. We got one. While not located on the west side of the building, the teacher's class representative and her special needs and physically emotionally disabled students were escorted out of the classroom closet. Law enforcement were pressuring her to move quickly despite her special needs conditions, which otherwise impeded such a rapid response. Marco says Rakita doesn't get out of bed for less than 5,000 viewers. Well, everyone has to start somewhere, man. Rakita kicks ass. Rakita has a 500,000 people. And yeah, sometimes he gets a lot of people. So I have like 1/10 of the people watching my stream for 1/5 of it. So I'm like half as good as Rakita, I guess, which sounds about right, to be quite honest. So if Nick Rakita is getting 5,000 viewers for 500,000 subscribers, that suggests that he's getting 1,000 viewers for 100,000, right? Because that would be math, right? If he's getting 500,000 viewers for 500,000 subscribers, then he's getting 1,000 subscribers for 100,000. I'm getting half that. So that suggests I'm half as good as Nick Rakita, which is probably true. But maybe one day I'll be as good as Nick Rakita. Maybe not. We'll see how it goes. I might have to disable the noise. That's getting a little bit annoying. Let me see what I can do there, because it's all the people liking the stream. Okay. I don't need all the alerts. Hold on. Let's see. Where is the sound coming from? Hold on. Talk amongst yourselves while I fix this problem. Yeah, save that. Okay. Alert box. Follows. Okay. There it is. Alert animation, alert enabled. It says there's no audio file. Why is it giving me? Stop. What if I save it now? I could disable the alerts completely. I might do that if the noise doesn't stop. All right, I'm going to disable the alerts because that's way too annoying, and I can't disable the sound for some reason. Subscription, donates, host. Damn it. Bits, raids, merch. I don't know if I can disable the noise. Cloudbot redemption. Okay. Please make the dinosaur stop. I'm trying. I'm desperately trying to stop the alerts. I'm in the back end of Streamlabs trying to figure this out. Give me a second. General settings. Let's see. Alert moderation delay, disable alert delay. Why is it doing that? I'm liking the stream. Follows. This is getting annoying. Donations. Hosts. Disabled bits. Disable bits alerts, I guess, see if that helps. Okay. Raids. Disable. Merch is enabled. Cloudbot redemption is enabled. Streamlabs Ultra. Disable that. I apologize for the noise issues, guys. I apologize. I'm doing the best I can. I've never streamed to Facebook using this software before. So we're learning as we're doing. I can add widgets to my screen. Damn it. I'll have to disable the alerts completely. It's the only way I can make this work. All right, I've disabled all alerts. So it won't pop out on screen anymore for anything. So it's the only way I can make this work for now. And in the future, I might not be able to stream to Facebook unless I can make that stop. So I've disabled all alerts. Well, located on the west. Okay, we read that part. The teacher representative immediately texted her husband, who, after being mistaken as the first responder, had been helping to evacuate other students across campus. She also sought information as to her son, who was in lockdown in the school cafeteria. During the entry of this time, the chief remained inside the building, and according to the sergeant, was in charge of the response, despite not having the capacity to receive dispatches and communications. For example, both the chief and sergeant were unaware that the United States Border Patrol Tactical Unit were assembling and operating on the opposite side of the building from where the chief and sergeant were located. At approximately 11:44 a.m., the shooter started shooting again, providing further proof that he was an active shooter. No officer responded, including the police academy instructors, the constables, nor other officers. Rather, the assembled officers saw fit to search for a negotiator in Bullhorn to negotiate with him as if he was a barricade subject rather than an active shooter. Am I on Rumble right now? No, because Rumble doesn't have a single stream key, so it becomes really problematic. Despite being unaware as to whether the doors were indeed locked, the chief determinedly sought a master key when, as chief of police force, the procurement of such a master key should have been accomplished in short order, one would think. Nevertheless, the chief of police stressed that before any attempt to enter the classroom could occur, he needed a master key and breaching tools. Despite awaiting the arrival of what he conceived as being the only means of entering the classroom and neutralizing the shooter, there was no incident command in place such that the chief of police could have been informed where these two necessary instruments had arrived on the scene. While the chief was orchestrating his response from the south side of the west building, an entirely separate response was being undertaken from the north side of the building. On the north side, officers from the police department, from the city, including acting chief of the city's police department, Pargas, Lieutenant Martinez, and Sergeant Canales, were stationed awaiting some command response. Acting chief acknowledged that he was never in communication with the school district's chief, nor with other law enforcement officers on the north side of the building. It was the acting chief of the town's understanding that the chief of police of the school must have been coordinating the law enforcement response given his supervisory jurisdiction over the school. According to the chief of police of the town, the Uvalde Police Department was merely there to provide support. As such, the chief of police of the town did not assert jurisdictional authority over the chief of police of the school, and the school's police department set up a command center, nor did he seek to coordinate with any other agencies. Rather, the chief of police of the town was awaiting arrival of the Department of Public Safety or others who he assumed would be providing better equipment. I really apologize for all the noise issues on the alerts. I really apologize for that. That's my responsibility as a streamer. I had thought I had disabled all the noise, and for some reason it wasn't working. And I assume it's coming from Facebook, and I couldn't find anywhere to disable those noises, and I apologize. And I apologize that I've had to disable the alerts generally, because I like to acknowledge on screen everyone who helps to support this channel. I figure it's the least I can do to help show you thanks, because sometimes I can't read it right away or acknowledge it right away, and I figure giving it acknowledgement on screen is the least I can do to help show thanks. And I apologize for the noise issues, and I'll work to correct them in the future. It's the first time I've ever tried streaming to Facebook using this interface, and so the alerts are coming from someplace, and I'm not sure where. Anyways, back to the stream. However, where the Department of Texas Rangers did arrive, law enforcement at the perimeter, who are unaware. You think it's a sound alert from Twitch? You think it's from Twitch, not from Facebook? I think I might have found it. I did find it. I found the setting. Oh! Victory! Putting it back on screen. The alert box is coming back. I figured it out. Thank you. You inspired me to check something. All right. It was coming from Facebook, and I figured out why, and I disabled it. Lol. Anyways, however, when the Department of Public Safety Texas Rangers did arrive, law enforcement at the perimeter, who was unaware of what was happening inside the building, instructed them to merely assist with the perimeter. Such instruction was reaffirmed by the Department of Public Safety commanding officer, Captain Joel Betancourt, who directed his team to remain on the perimeter and not to enter the building. Betancourt ordered the team to stand by and await the arrival of a more highly skilled group to speak for the dead. Who were on the way. Captain Betancourt also ordered the DPS team that was gearing up and poised to breach the classroom to stand by. Yes, good, the alerts are back. Captain Betancourt ordered result in a large contingent of DPS personnel on site to disregard their training and refrain from taking immediate and swift action to neutralize the shooter. Such command resulted in the majority of 91 strong DPS units to wait more than 70 minutes into a 77-minute long shooting to take any action. Upon information and belief, Captain Betancourt was carrying out both the Department of Public Safety, Regional Director, and DPS overall directors' directives as to how they should engage while responding to an active shooter at Robb Elementary, despite the state mandated and required protocols they were required to undertake. However, DPS Special Agent Luke Williamson ignored such instruction and proceeded along the north side of the building and began clearing students and teachers along the hallway. Well, thank God someone was doing something. So, Luke Williams, we salute you for trying to get involved and at least get students out of harm's way. That is something. It's more than the nothing all your compatriots were doing. So, good job. While interfacing with other officers outside Room 11 and 112, the DPS agent, Williams, was informed they were waiting for instruction from whoever is in charge figuring things out. After discerning that law enforcement response was seemingly unfolding in a haphazard manner and without centralized command, DPS agent Williams was required to follow the alert protocol by asserting authority as a Texas Ranger. So Walker, Texas Ranger, isn't here. We've got this guy, Texas Ranger, to take the reins and setting up a command center and tying the response. However, Agent Williams, as well as 91 other Department of Public Safety personnel on scene, failed to take charge despite their mandate and jurisdictional authority to do so. Meanwhile, at the perimeter of the school's campus, many parents had assembled seeking to retrieve their children. They were vehemently denied entry onto campus by law enforcement, despite having received no affirmative communication apprising them of the state of law enforcement's response. Approximately 20 or so minutes after Ramos entered the building, a group of terrified parents pleaded with law enforcement to permit entry, which is forcibly rebuffed. The students' parents were forcibly held back, pinned to the ground, pepper sprayed, and tased. So I guess those are potentially some actions, but I don't know that we can get to where we want to be from that, but at least it's an action. But one such parent, however, was to break through the group of law enforcement. She ran to the building and rescued her two children. So one mom got through all the police, who incidentally didn't run into the building after her to stop her, and were able to rescue her two children. So one mama bear was able to make it through. In or about the same time frame, the word got out that there was an assuring active shooter at Robb Elementary. One of the parents received a call from her sister informing her that such a nightmare was unfolding. The son and granddaughter were in attendance at school that day. One of them was fourth grade and one of them was in third grade. You have a child in fourth grade and a granddaughter in third grade? Okay. At first, they didn't believe her sister as there's nothing posted on the school's Facebook page. So see, some people are still using Facebook out there, people, which in the past the school was sure to communicate. Panicking, they drove in the direction of the school and after passing the school street, drove towards the back of the school near the funeral home. After the full funeral home, several parents and law enforcement were assembled. The parent determined to find her son, but was thwarted by law enforcement. A woman was gathering the names of students from their parents and promised to determine whether they were saved. They provided their children's name. Other parents were banging on doors and windows looking for answers as to their children's safety. When the woman with the list returned and wasn't able to confirm presence, the parent panicked, as one does. The parent forcibly screamed and cried, panicking that their child had been murdered. In pressing to determine if their son was alive, they received word that the child was alive inside the school. After hearing the school was going to load the children onto school buses and bring them to the Civic Center, the parent left for the Civic Center to see for her own eyes that her child was safe. After lining up the Civic Center, she was finally reunited with her son. The teacher told the parent how proud she was of the child's bravery and how strong they were during the experience. Yeah. As events unfolded inside the building, unbeknownst to one of the police officers, Pargas, Homeland Security's unit under the command of Paul Guerrero, also a hero who should be acknowledged for his heroism, right? His command, I'm sure, is going to come to the rescue. Paul, over here, had been assembling or themselves awaiting an order to breach. From whom, one wonders. Guerrero was well informed that the students were trapped in the classroom with the school shooter. Nevertheless, he informed his officers that they're going to take their time breaching the door. Between the time period of 11:37 and 12:50, surveillance footage depicted a steady stream of law enforcement agencies moving in and out of the north hallway, purportedly positioning and preparing themselves for the eventual restraint effort. $5 from Ricardo Ospinilla. If law enforcement spent this much time stopping the shooter as they did the parents, less people would have died. Yeah. Yeah. Despite the fact that the school district chief of police and the city's chief of police were awaiting the arrival of ballistic shields in order to effectuate the breach of the room, surveillance video taken between the hours of 11:52 and 12:21 depict the arrival of 4 different ballistic shields to the north end of the building. A rifle-rated shield arrived at around 12:20, some 30 minutes before the classroom was finally breached. However, the chief of police of the school district, who was located at the south end of the building and was operating without the assistance of a centralized command, was unaware the shields, particularly rifle grade, had arrived. Similarly, the school district chief, thank you, Jennifer. That's very kind of you. $5 just because. That's very, very nice of you. Thank you very, very much. I do really appreciate, by the way, everyone who helps to support the channel financially. It really, really does help, incidentally. This is now my primary source of income. And so I need to be able to eat. Plus, as I mentioned, it helps. It helps to get camera equipment. It helps to get better microphones. It helps to with remote streaming, where we had some technical problems, but we were able to overcome that. At least we had a decent webcam and we had the lighting, so that was nice. And the audio was a little bit hit or miss, but we did what we could with what we had at the time. And I've since gotten additional equipment to help in the future, so that problem hopefully won't occur again. And it will help with travel to see trials that are, for example, not streamed. For example, the upcoming Colt murder case in Idaho with Chad Daybell and Lori Vallow, because the judge is looking to not broadcast that. It would be nice for me to be able to go there in person and share my thoughts in person. So you had someone who could report on it primarily, and that takes money. If I'm going to go to a town and I'm going to be there for potentially several weeks of hotel rooms, that's expensive. And so I appreciate everyone who helps to support the channel so that things like that are possible. And also potentially get an apartment with a second bedroom so that perhaps I can convert that into a studio and make it a little fancier. Or perhaps hire professional editors to help with editing. It helps. It helps the channel grow. Thank you very, very much for all your support. We really do appreciate it. And remember, you can help to support the channel. If you're on a budget, you can help to support the channel for a mere 99 cents a month. If enough of you support at 99 cents a month, it adds up. And I try to make it accessible to everybody so that everyone would be able to join. That's one of the reasons I made it 99 cents, because I know that for some people, money is really tight. And I appreciate that. That's one of the reasons I made it literally the least YouTube will let me charge you for $1 a month. So I value everyone who's able to do that. It really does help. Thank you. Yeah. On or about 12:15 p.m., a student from inside the building called and reported that her teacher, Miss Morales, was alive but had been shot. Miss Morales was the wife of the Uvalde police officer who had received a call from his wife confirming that she had been shot. This 911 call followed an earlier call where a student called informing 911 dispatch there were 8 to 9 students alive in the classroom. In or about the same time, defendant officers, including the acting chief of police, Pandora Fox donates $2, says, "We got you, wish it could be more." Hey, every dollar helps. Every dollar helps. I understand that for some people money is tight. Every dollar is helpful. Am I coming to Moscow? I'm coming to wherever the trial is in Idaho, which I forget where it is, but I don't believe it's in Moscow. I don't believe that's convenient to the trial, but thank you. Maybe I can find housing with somebody in the area. But, I can't necessarily rely on that. And also for a lot of practical reasons, it may not be possible, because I'll need space and I'll have to be quiet and I'll have to be able to come and go. And, it could be a thing. So having my own space might be more desirable. So anyways, we'll see what we can do. Anyways, the 911 call followed an earlier call where a student called informing 911 dispatch that there were 8 to 9 students still alive in the classroom. In or about the same time, defendant officers, including acting chief Pargas, received a radio dispatch that one of the classrooms were full of victims. The acting chief responded, "Oh, okay, thanks," and after informing Border Patrol the victims, stepped out of the school building for 30 minutes. So with active knowledge, if not earlier, and I would argue earlier, but at least at this point, he has active knowledge and he's like, "Oh, okay," and then steps out of the building. Despite that such information reinforced the fact that officers were facing an active shooter scenario, defendant officers persisted in responding as if it were a barricade scenario. Such response continued despite officers hearing that the school shooter began firing his weapon in room 111 some 37 minutes after the last shooting had occurred. Just before 12:30 p.m. on the north side of the hall, a group of officers established a position closer to room 111 and 112, as well as stage medical triage equipment on the east side of the hall. This took place under tactical command of, I believe this is the U.S. government. The acting commander arrived at the north side with a breaching tool, and again, without coordinated communication. The chief was unaware that they were poised to breach into the rooms. In taking control of the situation, Guerrero determined that the use of the halogen breaching tool would not work fast enough, such as officers would face a heightened risk of gunfire. Similarly, in acquiring and testing a master key on an adjacent classroom door, he determined the master key he received from the school did not work. Although there was reasonable doubt as to whether the room was locked at all, they obtained a second master key, which they determined to work. Nevertheless, despite having all the elements in place to breach the class and taking charge of the command, they waited to give the order to move forward. Finally, after assembling a stack of officers as well as charging one officer with holding the rifle shield, the commander commanded the students through the door, "Yell if you need help," and after Ramos shot the responding student, opened the door where he fired his rifle at the stack. The stack killed the shooter with a barrage of bullets. Although such undertaking unfolded in a matter of seconds and was otherwise required response, law enforcement took 77 minutes to accomplish what they were duty bound to expeditiously perform. Each second of those 73 minutes exponentially compounded the harm to a degree it's indelibly etched in the hearts and souls of survivors, their families, and the community at large. Yeah, I bet that's true. I bet that's going to fuck a lot of people up for a long time. That's a lot of therapy, man. After receiving a dispatch from approximately 11:40 a.m., support staff, upon arriving at the funeral home with the school bus, found a chaotic and crazy scenario with parents screaming, law enforcement scurrying to and fro and awaiting ambulance, and impossibility to maneuver the large bus through the chaos. Prior to arriving at the funeral home, the bus driver was not informed as to what was happening. Dispatch merely informed her to pick up children and take them to the high school. It was only upon arrival at the funeral home did she learn what was tragically unfolding. Panicked and unable to drive forward or backward, they locked her bus and waited instruction. Sometime around 12:50, the school bus driver heard a barrage of gunshots. Minutes thereafter, I think this is federal law enforcement officers with bloody children in their arms came storming onto her bus with 6 profusely bleeding children. The officers sat the children in the back of the school bus. Great, just great. It's going super, super great over here. It's going just about as well as we've been told. The facts are a horror show. The moral failings and even professional failings of these officers are beyond description. The horror show that's facing these children is beyond description. The parents preventing the parents from coming in, or the police preventing the parents from coming in and macing them and detaining them is callous and horrible. I really hope we can find some cause of action that's going to work, given the state of the law. Yeah. I'm not sure how we get to a 1983 lawsuit at all. Not with cases like Winnebago versus DeShawnee being in place. I'm not sure how we do that. Go Ho Shane has gifted 10 memberships to the viewers. Thank you very much, Go Ho Shane, for gifting memberships to the channel. We do appreciate everyone who helps support the channel. And remember that you also can join as a member for a mere 99 cents, and it is appreciated if you do. Realizing that 3 of 6 children were in a more critical state, I think federal law enforcement received 3 and carried them out to an ambulance. The remaining 3 children were also profusely bleeding, with the officer commanding the school bus driver to quickly drive to the hospital. As the bus was blocked from going forward, law enforcement had to move vehicles and clear the traumatized and panicked parents to allow the bus to depart. We're using a school bus to take children to the hospital at this point. A police car escorted both the ambulance and the bus to the hospital. Upon driving out, they witnessed the bodies of deceased children being lined upon the sidewalk, as well as EMS applying CPR in an attempt to save lives of one of the teachers. After arriving to the hospital and delivering the traumatized and bleeding children, the school bus driver drove back in the direction of Robb Elementary with one of the federal law enforcement officers. She was ordered to return to Robb Elementary to pick up children and deliver them through Uvalde Civic Center. However, as her bus was covered in blood, both on seats and throughout the entirety of the floor, she drove back to the bus garage to pick up another bus. Woof. Upon arriving back to Robb Elementary, the school bus driver witnessed a chaotic mess of teachers with traumatized and screaming children and parents being blocked by law enforcement. As the children were being loaded onto the bus, the school bus driver saw that many of the children she regularly transported to school. The children were screaming and crying all the way to the Civic Center. Upon arriving at the Civic Center, the school bus driver witnessed parents clamoring to locate their children, but were kept from reuniting with them by law enforcement until after children entered the building. Parents were requested to show proof they were indeed the children's rightful parents. After dropping off the children at the Civic Center, the school bus driver was required to return to the elementary school and pick up remaining children. She did so, and after making a last run to the Civic Center, returning the bus to the bus garage, finally allowing herself to break down and express the horror she just experienced. Well, school bus driver here sounds pretty based. So, good for you for playing your part in actually trying to help some children in a unfolding disaster scenario. You did your best with absolutely no training of any description, I assume. And you did a fine job. You're based. Although the school bus driver been a driver for several years, the school district had never provided training on proper measures to take when executing school evacuations. Yeah. All right, post-attack. The narrated facts above glaringly expose law enforcement's complete and utter disregard of the standards and protocols required when responding to an active shooter. In total, 376 law enforcement who were on hand, and not one complied with the absolute mandatory requirement they immediately distract, isolate, and neutralize the active shooter. Reports compiled post-attack indicate that despite the state's mandated requirement that all law enforcement in the state of Texas undergo active training, only 50% of the officers who had responded had received the training. Well, that's still 50%. That's still like 170 people. In addition, defendant officers failed to establish an incident command. Each law enforcement agency who arrived ignored the all too apparent reality they were confronting an active shooting scenario, and there was no coordinated, centralized command in place to orchestrate. In addition, the response was so completely ineffectual that after Ramos was neutralized and the students were liberated from the classroom, the students, including those wounded, were evacuated to the hospital on a regular school bus rather than the required ambulances. Well, in an emergency, you make do with what you have to some degree. And still, bus driver is based. The school buses were without EMT or other adults on board, so when the buses arrived at the hospital, the children who had been wounded had to limp off the bus. As law enforcement officers with the primary state law enforcement agency, the 90-plus Texas Rangers who were on scene, so 90 Texas Rangers, they're not feeling as based as Walker, Texas Ranger, had me believe right now, were imbued with jurisdictional authority over the situation, yet permitted the void to persist on an unconscionable 77-minute delay. Although there was a vague assumption that the chief of police of the school district had assumed command, the fact that he had positioned himself within the south side of the building and was therefore out of contact with response efforts assembling on the north side, such assumption was clearly unreasonable. Fair enough. They had no reason to particularly believe that. I'm not sure they had any reason to particularly believe that he was there at the time, to be honest. This is particularly so given that responding agencies had all but undergone both state-mandated alert active shooter training, as well as their own individual agency training, and thus were well aware of protocols and command chains that were required. It was glaringly clear to all of law enforcement agencies that such protocols were not in place and functioning throughout the fateful 77 minutes of protracted confusion and unimaginable physical and emotional suffering endured. Similarly, as the primarily required response was to stop the killing, the entirety of law enforcement never attempted to breach the classroom, nor take affirmative steps to determine whether the rooms were breachable. For example, checking to see if the doors were unlocked. The chief protracted search for a master key, despite his position as chief of police of the entirety of the campuses, consumed his attention. Yeah, it's a little weird that the chief of police of the schools doesn't have a key for the school, but okay. Consumed his attention, thereby delaying the otherwise required rapid neutralization of the shooter. Neither the chief of police of the school nor any other law enforcement at the school's principal or head custodian for a master key, which would be like kind of a reasonable place to look, one would think. Such oversight encapsulated the entirety of law enforcement's response, as there was a vacuum of communications, both literally, as radio and cell phone service within the building were purportedly non-existent, and figuratively, as there was no incident commander to serve as a conduit for communicating. In an attempt to obfuscate and camouflage the complete and utter disarray of law enforcement, the initial public statements and press briefings provided by the Department of Public Safety initially painted an inaccurate and exaggerated positive picture of law enforcement. The DPS regional director briefing provided the information that Texas governor relied upon in a press conference the day after the massacre. The governor repeated a false narrative. The entire incident only lasted as little as 40 minutes, which, by the way, is still pretty long. And praise was due to the officers who rapidly devised the plan, stacked up, and neutralized. Thus, the governor presented a false narrative. On account of preposterous length of time it took defendant law enforcement to finally neutralize the school shooter and liberate the students, the amount and degree of trauma, distress, and life-shattering anxiety they had incurred had exponentially increased within each moment defendant refused to affirmatively act. Defendants' conduct significantly prolonged the time they are required to assume lockdown conditions on account of resulting emotional and physical scarring. For example, one of the students who watched after his beloved teacher endured close to 70 minutes of agony responding to a gunshot to her abdomen, and his friend, attended to with bloody and severed nose, has refused to either leave his house or parents' side since the shooting. He obsessively draws window blinds to his house and repeatedly locks doors and sleeps in his parents' room. Although expressions vary, such emotional and physical manifestations have rampantly expressed themselves. Yeah, so I have no problem with basically these statements of facts, right? These statements of facts are probably basically true. They're probably basically true. I mean, we could fight over the finer details if we wanted to. And I'm sure that if I were the attorney for all these people on defense, we could fight over the finer details of some of this stuff. So is it all perfectly true? Probably not all perfectly true, but is it true enough? Yeah, it's true enough. Let's say it's 90% true. That's probably reasonable. Or even 80% true. That's pretty reasonable. Like, yeah, it's clearly manifestly 80% true. It's clearly manifestly true that 370 whatever officers did not breach the doors for 70 minutes. Right? And that's kind of the only fact you really need in the end. You can confirm the time that the shooting started, and you can confirm the time the breach happened. So all you really need is that one fact. The rest are details. Right? The rest are details. They're horrifying details. But that's really the only fact you really need here, is that for 70 minutes, they didn't breach the door. Even though there are like 300 officers on scene. So it's true enough. And it's certainly true enough that these people have suffered harm. Like, looking for harm to these people is not a problem. So we got that. Let's see if we can find a cause of action that will allow us to connect the two. We got the police department behaving like complete crap, and we got a lot of harm from parents and children. Let's see if we can find a cause of action. Pursuant to federal rules of civil procedure, plaintiffs bring this action as a class action on behalf of themselves and all other similarly situated students, teacher, and support staff who are located within the perimeter of the school's campus, and the students' parents regardless of location. The danger posed to lives, health, and safety of these class plaintiffs was exceptionally increased on account of defendants' affirmative conduct. What affirmative conduct? In refusing and failing to comply. No, that's not going to work. Affirmative conduct in refusing and failing to comply, that's not affirmative conduct. That's not affirmative conduct. I wish it was, but it's not. Alternatively, to the extent the court should find the class is unavailable, they reserve the right to designate their action as a mass action pursuant to requirements of code. Fine. We will skip class certification issues because that's not really the important issue. Right? You can't get to it doesn't matter whether or not we can bring it as a class or not if none of them can bring it individually. So we'll skip through the class action stuff because it doesn't matter. So they're trying to prove class action certification. Fine. Let's give a cause of action. 42 USC 1983. Yeah, we got Castle Rock versus Gonzalez and Winnebago versus DeShawnee. I don't see how we're going to get through that, but let's find a way through. Plans incorporate Section 42 USC provides that every person who, under color of any law, causes to be subjected any person to the deprivation of rights, privileges, or immunities shall be civilly liable. A person is liable for violating rights on account of official or unofficial policy or custom if their actions or if they're in custody municipal liability attaches to the independent school district on account of custom and practice of failing to ensure compliance. No. Upon information and belief, the school board had provided the chief of police with final policy making of over safety of police, including assurance that their compliance. In summarizing the exhaustive account below, the following security, infirmities, and safety infractions exist: substandard fencing, complete lack of enforcement over mandated requirements that provide both exterior and inferior doors are being locked, interference of campus emergency warning system, failure to amend the lockdown system. Upon information belief, the school board was apprised of the above, but failed to take affirmative action. Upon account of custom and practice of preventing noncompliance with required rules, noncompliance, the defendant, through deliberate indifference of its final policymaker in chief, violated the 14th Amendment rights. Deliberate indifference. Deliberate indifference works in a custody setting. Deliberate indifference works in a custody setting. That's the standard if they're in custody. But they're not. By affirmatively disregarding, no. The state's noncompliance, no. With required protocols in response, the chief policymaker used their authority to create a dangerous environment by consciously disregarding a known risk. No. On account of such conduct that caused lifelong harm. Liability also attaches for violation of 14th Amendment rights on failure to comply. No. By failing to take affirmative action. No. As well as affirmatively inhabiting inaction take place. No. Display deliberate indifference. That would be the standard if they're in custody. No. City of Uvalde's liability exists on account of Uvalde's law enforcement final policymaker deliberate indifference. No. By failing to comply. No. To take affirmative action. No. On May the 24th, the Lieutenant Pargas was acting chief of police who was on the scene, charged with complying with the Texas protocols for responding. Acting chief of police undertook his supervisory decision-making authority by making a deliberate choice to stand down. No. Deliberately indifferent. That's the wrong standard. Lastly, a municipal may be held liable for failure to supervise or train when the supervisor either failed to train the subordinate official. A causal link exists between failure to train or supervise and the failure to train amounts to deliberate indifference. Wrong context. Deliberate indifference to what? Wrong standard. Here, on account of the protocols for responding to an active shooter to neutralize, even at the risk of life, they magnificently failed to follow this non-negotiable prescriptive protocol. No. Such non-feasance is understandable given the reports indicate they failed in fact to provide training. No. Additionally, although they unconditionally require that the immediately established command center, such mandated response was disregarded. No. Thus, the complete and utter failure to comply with the mandated requirements, inadequacy of training, although thankfully there hadn't been any prior shootings, the reprehensible failure shows deliberate indifference. That's the wrong standard. That'd be the standard if they're in custody, which they're not. On account of acts of omissions resulting in violations, the municipalities were direct and, that's a typo, that should be and, proximate cause of the injuries, including not limited to, blah, 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 blah. No. 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 There's no cause of action here. Not under the current state of the law. There's no cause of action here. Not under the current state of the law. At least to the police department. And at least to the police department and the police officers. No. And I'm very, very doubtful as to the school district itself. Yeah. Yeah. You love it how I read it like, nope, I wish I didn't have to. I wish I didn't have to. But, for better or worse, the law is the state of the law. And state of the law is like, no. Someone asked, aren't duty of care precedent involved when the police failed to show up at all? Uvalde's a bit different. They took control and just ignored. I don't believe that's true. No. Unless the police create the danger, which they didn't do. The police didn't create the danger. The police can, in fact, just show up and do nothing. That's, incidentally, Warren versus DC. Warren, DC, the police did show up to the scene and then did nothing. So, yeah. I mean, Warren versus DC is a little different in that they didn't stay very long. I think they either drove by, I think they just drove by the scene, and they might have knocked on the door. I forget exactly, but either way, they showed up and then did nothing. And no. 14 USC provides every person cause to be subject to private due process clause. No state shall deprive any person of life, liberty, process. The state didn't. State a cause of action. They must show that they have asserted a recognized liberty interest. Yeah. And they're intentionally or recklessly deprived of that under color of law, which requires action. Protects against the government's interference with bodily integrity. While the 14th Amendment right to bodily integrity do not normally extend to circumstances where harm is caused at the hands of a private actor, when a state actor acts with deliberate indifference to a person's plights and creates a more dangerous circumstance, if they created a more dangerous circumstance, but they didn't create a more dangerous circumstance. They just didn't do anything. A viable state-created danger claim requires the state to take affirmative. Yeah, this is it. A viable state-created danger claim requires the state to take affirmative steps to create the danger or make the plaintiff more vulnerable to it, which they didn't do. They did nothing to create the danger. They didn't make the plaintiff more vulnerable. The plaintiff was just as vulnerable as they would have been if the police weren't there at all. Here, the defendants were performing under state color law and being sued in their individual capacities. But for the director, they above were on site and thereupon on their own volition directly acted or ordered subordinates to act in contravention. As the above statement facts, each of the above defendants acted in a manner deliberately indifferent. They're not in custody. They're not doing anything. There's no duty. Deliberate indifference only work. The reason, by the way, it's the standard in custody is because that's the standard where the police have an affirmative duty. It applies to jailers, incidentally, prison officials. It applies to the government at large. So if you're in the police's custody or the jailer's custody, then deliberate indifference is the right standard, right? Because then you do have an affirmative duty. That's why you have an affirmative duty in those situations if you're the government. The person can't protect themselves because they're in the government's custody. You've taken away their ability to protect themselves. So the government has a duty. But here, they're not within custody within the meaning of the law, as the case law has unfortunately said. I don't know if there's any binding law in the Fifth Circuit on this point exactly, but jurisdictions that have considered it in the past have said there's no duty, that they're not within the meaning of custody. I don't think there's a U.S. Supreme Court case on that, but there might be. $10 asking, are there any law tube going to be covered in trials of Trump? I've covered some of it. If we ever actually get to a trial, then sure, I'll cover that. Ricardo Ospania says, but the police were not there. The parents could have gone in and rescued the children and shot the shooter. That's a very thin thing to hang your hat on. Plus, the police on the exterior preventing them from coming in would be standard police protocol. So I don't think that should be a thing. Schools are not federal property, by the way, Karen. Schools are not federal property. Schools are almost always state property. More strictly speaking, locality, but localities are the state. Schools are not federal property. Unless there's a federal school, which there might be somewhere. DC, I guess. $20 from Mandalore Wise, who says, could there have been a better case against the commander if they argued him ordering the other officers to disobey their officers with actual knowledge or disregard? No, because the problem is like the protocol can't really mandate for a lot of reasons, because you can imagine a scenario, or at least I'm sure we could if we all put our thinking hats about it collectively. We could probably imagine some sort of scenario in which the police should disregard the trainings, right? I mean, if we put our thinking hats on long and hard enough about it, we could probably think of a scenario like this. The trainings can't be God, because the scenarios can't think of everything, and there probably is some set of situations in which it wouldn't be reasonable to defy the training. Right. So like, would there be a scenario in which it would be reasonable for an officer to say, like, don't do this? Maybe. And even if not, like, still, even if that is not reasonable, you still have a problem of the affirmative duty. So even if you're like, no, there was no reasonable situation, either as a matter of law, so it can't be done, or as a matter of fact, not here, you still have the affirmative duty problem of how do you get the students to have, how does that harm them? Because they have no duty. Yeah, they're not. They're according to Earthling, according to the case law that currently exists, the current case law that exists, kids in public school are not in custody. I believe there is U.S. Supreme Court case on point on this. I'm not sure which one, but I believe there is a U.S. Supreme Court case on this point. But custody means arrest, or the equivalent of arrest. It means prison, or the equivalent of prison. Kids are not in custody in this sense, because they're not under arrest or any equivalent. So the case law that exists, unfortunately, no. The USA is scoring goals in the World Cup. Yay. Receiving federal funds creates attachment. Someone asked about federal funds. Karen asked about federal funds. Federal funds don't make it federal. Federal funds can, to some degree, imply requirements, but those requirements have to be spelled out by law. So the receipt of federal funds does not make you obligated to obey federal law writ large. It makes you obligated to obey federal conditions that are attached to the money. So the federal funds for education are presumably premised on them being used in relation to education, to further education. So there's almost certainly no like contractual obligation that arises from this. And for what it's worth, the conditions set by the federal government, cannot be too burdensome because of federalism principles. So the federal government typically bribes states into doing things they wouldn't otherwise do with money, because states say yay money. But those bribes cannot be unduly coercive. Your case law on point for that is South Dakota versus Dole. There is a limit somewhere. What the limit is exactly unclear, because South Dakota versus Dole said, well, this isn't the limit. But South Dakota versus Dole teaches there is a limit. So the federal government can bribe the states, but they can't unduly coerce the states. So where that limit is a little bit tenuous. But the federal government, first of all, the conditions have to be specified in the money. So it's only those conditions specified in the money. And second of all, some of those conditions themselves might be illegal, depending on how far they're trying to go. But yeah, that's your limits of federal money. It's a good question. It is a good question. It's a good question. That's why I highlighted it and answered it. It was a good question, Karen. It was a good question. Yeah. Primarily, the danger faced by plaintiffs and class members were significantly enhanced by the defendant principal and the chief of police. Could you also fund the police after they failed to act? You can only fail to fund them for breach of the conditions attached to the money, right? By accepting the money, you accept these conditions. So if you do other things, no, you can't take away their money. You can only take away the money, well, to the extent that the money is ongoing. Like, obviously, the money can expire on its own terms. So it's like, oh, we're only going to give you money for a year. Well, if after the year expires, we don't want to give you more money, then we didn't do anything right. It's basically contract. It's basically contract, if you like. It's that the federal government is barred at some extreme from some conditions of contract. But otherwise, it's contract, right? So you accept the money. If the contract expires by its own terms, we were only going to give you this much money, we were only going to give it to you this long, then fine. If the contract is breached because the states failed to do XYZ, and so we're going to take away that money because you breached those conditions, then fine. Unrelated conditions, no. Not within the terms of its own contract, no. To the extent the law might allow, you might be able to, and also, like, it's not, the federal government can't just do things for the hell of it either. So, like, if it were in the regulations that, if we don't want to give it to you, then yeah, but typically the regulations aren't written that way. So Uvalde will probably continue getting federal funding as it was before, because it hasn't violated any of the terms of that grant. And then, there is this limitation. Incidentally, there's limitations in normal contract law as well. Like, there are conditions that you can't put in a private contract. We call them unconscionability. There are certain things that you just can't do in a contract. It's unconscionable. It's just when it comes to the federal government, we have this additional provision because of federalism of this unduly coercive thing. So the federal government can't do more things than a private citizen could do. A private citizen could bind people into a contract that would be harsher than the federal government could versus the states, because it's between two sovereigns and we have to get in federalism and we don't have time for it. But yeah. Or even with the federal government versus a person. The federal government can impose more conditions, but still not unlimited conditions, because there's still limitations for other reasons. For example, the federal government can't violate the Constitution. So they can't offer money to a person on condition that they give up their religion, for example. Then we run into problems with the Constitution. But anyways, the principal, who, despite being aware they were compromised, consciously disregarded, no. Such circumstance came to pass when the faulty cell service inhibited a prompt emergency message to disseminate to teachers and staff. Such failure to warn significantly heightened the danger, including those on playing fields who were forced to confront by having to scurry inside the school building, as well as those in the building who were forced to frantically assume lockdown positions. The above dereliction, that's a problem. The above dereliction of duty, but the duties weren't to the children particularly. They might have had duties at large, which might allow them to be punished, for example, by being fired. But the duties they had weren't to any of the individual people. The dangers faced by plaintiffs were significantly enhanced by their conduct, where they are apprised yet face intentional disregard. No. Rather than appropriately order the law enforcement undertake it, they disregarded. No. Flagrantly ignoring responsibility. No. Thus, given lack of radio internet services, the chief of police was unable to receive or send communications, such that he was out of touch with efforts that were being undertaken on the north side of the building that was commandeered by the police. Despite being first responders in the building mere seconds after he slaughtered students, the defendants refrained. No. Thus, despite perceiving the necessity, he refused to do so, failed to assume a role, refraining from, stand down. Thus, affirmative steps? I don't think so. Procrastination, lack of coordinated response as affirmative steps? Nope. As the supervisor was in charge of the agencies, the unreasonable hesitation. You can just see the problems like emerging massively. I don't think the parents are going to settle though. The school district might offer them something to go away. Right. So, because like going into court and being like, yeah, we have no responsibility, which is the right answer. Like, so for purposes, they might offer them something, but they're not going to offer them more than like some, like tens of millions at best. And they're suing for 25 billion. So this is getting dismissed. All right. So special relationship. Good luck. A violation of substantive due process is additionally triggered where state action affirmatively acts to restrain an individual's freedom to act on their own behalf. Yes. Restraint on an individual liberty such that there state's custody and control that evokes a special relationship. This is absolutely true. This is absolutely true. This is where, if you're in custody, but you have to be in custody, hereby effectuating a perimeter that results in barricading the students, teachers, and support staff. The above students had affirmative duty to provide safety and protection on account of establishing special relationship. That's by effectively cutting off private avenues and failing to come to students, age, and staff for 77 minutes. I don't think so. I don't think so. I mean, I God bless you for trying to squeeze yourself into this. But even though the police were setting up a perimeter and refusing people to allow entry, we're not within custody within the meaning of the law. I don't think so. Similarly, the rights to make decisions regarding their children's custody was violated by forcibly preventing them in order to exercise their rights, which is severely compromised. I don't think so. That doesn't work because it's standard protocol to prevent people from running into an active scene for their own safety, the safety of others, the safety of the officers who might accidentally shoot them, and blah 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 blah. So like I don't think this works. I don't think this works. On account of their actions and omissions, which were the proximate and direct cause, pain and suffering, wherefore, no. Issue a cert class action, class-wide judgment, issue injunctive relief, require to institute training, required to do. We want $27 billion. I kept saying 24, so 27 billion. Plaintiffs, ward, blah, 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 blah. No. Well, there's your depressing black pill for the day. No. What would it take to create a duty to protect for the police? I'm not sure that you could. Well, I'm sure you could. I'm sure you could. You could pass a law that would be specific enough. But the problem is like how that would actually work as practice. How you would actually create such a law. How would that actually work? You know? Okay, so like let me work you through the problem as just an example. Let's suppose we want to say this is just an exemplar, by the way. Let's suppose we want to create a duty that like Colorado did or tried to do. Let's say we want to create a duty that a police officer must enforce restraining orders. Okay. So suppose a person with a restraining order calls the police and says, I'm afraid. I want someone to guard my house. My ex has said that they're coming by, or I believe I saw my ex's car drive through the neighborhood a couple times. I want you to come and stand guard at my house. Do we require that? right? And if you answer yes, we do, then you can see the problem hopefully rapidly emerging, right? Because if we did that for every single person that had a restraining order, it's like, oh, I think I saw my car, I think I saw the X in my car behind me in traffic. I think he might have been following me. Can you guard my house? Okay, for how long? How long does this police officer stay? How long does the duty attach? So the problem with it is like, and also like, suppose now that there's a incident across the street that's unrelated. Does the police officer have to continue standing guard, or can he go respond to that? So like, how would you implement such how would you implement such an idea in practice that would work? So I don't, that's the problem. Like, it's like, okay, how do you, when does the duty trigger? When does the duty trigger? To whom? For how long? Right? And so forth and so on. So there's a problem pragmatically. There's a problem pragmatically. And yeah. That's the issue. So I want to say thanks everyone, to all the people who were here this entire time. I really appreciated it. It was super awesome. You guys kick ass. I'll take some. Oh, let me go into the back end and check out the super chats and read the super chats. It doesn't include people who gifted memberships because that doesn't get captured, but I can at least read the super chats that came in today. And then I have to delete these super chats, old messages, because it's a little hard to find the new ones. Because I'm saving every single super chat ever. All right, so here were super chats that were received today. Sledge and Wedge gave 314 to say morning pie for your morning pie for you, court us in session, Judge Kurt. Kiwi New York Upstate gave €5 to say it makes no sense to sue your own government since you and every one of your neighbors has to pay a king's ransom and additional taxes to pay for it. Ricardo Ospania gives €5 to say it's sad that a good guy with a gun isn't the police. All these amounts are in euros. I'm not sure why, but okay. It's sad the good guy with a gun isn't the police. This is disgusting how cowardly the police was. €10 from Barco Verver, who said, please make the dinosaur stop. I eventually figured out how to make it stop. Mandalore Y01 says there's no downsize, lol. Pandora Fox said, those families deserve justice and to be heard. Thanks for giving them all a voice. Kurt, you are welcome. Ricardo Ospania gave €2 to say, good job, Kurt. Someone has to speak for the dead. Ricardo Ospania gave €5 to say, if law enforcement spent as much time stopping the shooter as they did stopping the parents, less people would have died. That's pretty based. Jennifer Foley gave €5 to say, just because. Pandora Fox gave €2 to say, we got you, Kurt. Wish it could be more. Hey, we appreciate it all. Magic T. Cossi gave SEK 50 to say, could you argue since they prevent others from stopping a shooter, they're accessories to a crime? No. Actually, could we argue RICO? No. I appreciate your enthusiasm and all, but no. Patricia Andrews says, thanks for this. Are any law tubers going to cast trial of Trumps? I covered some of it in the search warrant stuff. As it develops more, I might cover more of it in the future. Ricardo, apologize. Ricardo Ospania says, but if the police were not there, the parents could have gone and rescued their children and shot the shooter. Mandalore Y said, could there have been a better case against the commander if they argue him or any other officers to obey their police or actual knowledge or willing to disregard the shooter versus barricade subject? Mandalore Wise gave £5 to say what would it take to create a duty for police, and what do you think could be undesired side effects? And Mandalore Wise to be fair, I think this could be a good topic for Racket's law school convos podcast idea. I think you're right, and all those things. Well, thank you very much for all those things. I appreciate everyone who's here. To the 400 of you who are still here, thank you for being here to the end. Just a quick reminder to check the like button. Have you given it a like yet? And if you'd be so kind, for 99 cents a month, I would really appreciate each and every one of your supports of the channel. It helps the channel grow. It gives us the funding to potentially do stuff in the future that'll be fun and exciting and all the rest of it. So please, if you wouldn't mind, please hit that join button, hit the link in the video description, hit the link that the bot tells you about from time to time, all those things. I hope you enjoyed the stream. I enjoyed the stream. It was interesting, to be sure. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.